5:30, a few minutes past. We'll go ahead and call this meeting to order for the Board of Adjustments. First item on the agenda is the approval of the June 18th minutes. I get a motion? Motion, second? Motion and a second. Any discussion? All in favor? Motion carries. We've got 4 public hearings on the schedule tonight. Everybody that is here that wants to speak will get a turn to speak. We will ask that you limit your talking points to 3 minutes or less. We do have legal counsel here tonight to speak on these appeals. We're going to ask that you limit your talking to 15 to 20 minutes because we all know attorneys like to talk a little bit more. The first order on the public hearings is for Sri Sai Hospitality. And Michaela, if you'd like to talk about that for us,
Sure.
please, first.
This was tabled at the previous meeting, so do we need to take a motion to take it off the table?
Yes.
Do you want to
Okay,
do
so
that?
we need a motion to untable this. Got a motion and a second? All in favor, say aye. All righty. We are now open for discussion.
Okay. Sri Sai Hospitality have applied for a variance to waive the screening requirements of the vehicular use area on the southern property line that joins High Tower Road, and to reduce the required landscape buffer from an average of 10 feet in width, with the minimum dimension being 5 feet, to an average of 3 feet in width, with the minimum dimension being 2.54 feet on the northern property line that joins the South Danville bypass located at 3663 South Danville bypass. So this is the Super 8. This is the vacant lot next to it. They applied for a site plan amendment that went through Planning Commission at the June 26th meeting. They are coming to you all asking for variances for the landscaping on the site plan. These are the 2 requests here. One is along High Tower Road. Typically, we would require an average width of 10 feet for a landscape buffer with plantings of shrubs and trees along here. And then this is the second request here. Typically, we would require same thing, average of 10 feet. They're with a minimum 5 foot. They're asking for an average of 3 feet with a minimum of 2.54 feet for this. So they're providing all the actual trees and shrubs required, but they're asking for a reduction in the landscape buffer there. Over here, they're asking to waive all requirements for landscaping on that side. Clearly, it's to accommodate parking on the site. They exceed our parking requirements by 8 spaces with what's shown. They are showing a shared parking agreement here to the east on the existing site plan, or the existing Super 8 there. So they are going to show an additional parking area there. So they are exceeding our amount by 8 spaces, which is the exact amount here. So that is something to keep in mind. But those are the 2 requests. Are there any questions for me on that?
You said they're exceeding the requirement by 8 spaces?
Yep. Yeah, off the top of my head, it might be right here, but I didn't bring the whole site plan, but I believe they have 107 and we require 99.
Is the applicant here tonight? Like to speak?
Joyce Followell, I'm engineer with Abbey Jones Consulting. Did this layout for Mr. Patel.
Okay.
The reason we have maintained those parking spaces in that area is for future expansion on the other side of Super 8. It's not an immediate parking need, but on the overall site plan for the entire area that he has, we're needing those additional parking spaces. There's still 15 feet of grass verge area between the parking, the property line, and the road. So there's still adequate space, but it's not on the property. It's, I guess it's right of way.
Yeah.
Yep. That's along Hightower Road there. Along the bypass, there's a pretty significant space between where the parking area is and the actual pavement on the bypass, and there's a significant natural berm and.
On that side over there. Over there,
Yeah.
there's not a berm. That's what I was referring to.
Yeah, sorry, on this side, the
Oh, on that
bypass-
side.
Yep,
On-
the bypass would run along here, and then on this side, there's not. There's just, like
Right.
she said, some grass area.
Right, on the right, plan right, which
Yeah.
is south, there's grass between our property line and
Right
Hightower
here.
Road.
This is where the pavement runs, these two lines here, so there is some space. But obviously, with it being right-of-way, it's reserved for the city to come in and widen the road, add sidewalks, et cetera, so.
Right. On the plan left is, it's facing the bypass, and there's like a 20-foot drop-off, about 20 feet from the property line. The state's right-of-way extends past the top of the bluff. When you drive by, you see the bluff, and then there's the mowed space. There's probably 20 feet of mowed space that's actually not owned by the property. It is actually right-of-way. But we can't legally construct on the right-of-way. We actually are asking a variance to KYTC to put a little bit of fill on them. But from that area, from that vantage point, you're really not going to see that landscaping that's going to be setting back away from that bank, because you're going to be looking up at the bank, and the landscaping is back here. You'd be looking over top of the landscaping anyway, to be honest.
Yeah. If you can picture what you see for the Super 8 from the bypass, it'd be pretty similar vantage.
Yeah.
Right. This actually will be coming out much closer to the road than Super 8's landscaping.
Any questions?
You mentioned expansion, future expansion, where is that?
Long-range thought and goal would be to put another hotel between the Super 8 and the,
Well, it would be on the other
Hampton.
side of the Super 8.
yes, on the other side of the Super 8.
Let's see if I can, so here's the Super 8 here. This is a parking area for the Super 8. This is the site that we're talking about. They're looking in here. Is that correct?
Yes. So that would be the reason to use the gravel area in the back for parking and for shared parking. It's already gravel, so it's already causing a decrease in infiltration in that area. I know the goal is to not have a gravel area, so, let's put parking there because it's already gravel. Let's pave it.
Michaela, would the requirement be for blacktop back there? Or is there a requirement?
Yes, that gravel parking lot's been there for about 20 years, give or take, so it's grandfathered. They will be paving a portion of it with this plan that's coming through, but not all of it, and I believe the rest of it's gonna remain for now, so, yep.
It's kind of an overflow lot, basically.
Yeah, I think it's a storage overflow kind of area.
Any other
Lately, it's been
questions?
used as a construction staging area.
Okay, yeah, sure. All
Will
right.
it- Will it be a two-way, would it be a one-way in parking lot, or would it be a pass-through? Can you go completely in one side and go on out the next side, or do you have to come back out the way you came in?
So you can't quite see it here. This should be coming in and out the same way, but there's another entrance up at the gravel area that's going to be paved also. So there will be two
Okay.
entrances in and out. In the future, we mentioned a future expansion, then we would be connecting also on the left side.
Yep.
But that's, down the road, this one goes and does good. Then we could do some more great things.
Sounds good. All right, any other questions for her?
Have any questions for Mr. Patel?
Is there anybody, you're more than welcome to speak if you'd like to. You good? All right.
Thanks.
Is there anybody here to speak against the variance or for, in support of the variance? Nobody? Then we will end our public input portion and deliberate or look for a motion to approve or deny this. Yeah. All right. Got a motion by Willie, second from Lonnie. Any further discussion?
Yes, Mr. Chair, I think a motion to approve this
Sorry, Henry.
to grant a
Should've given
variance needs to contemplate some of the statute's criteria for that, and one of them is, are there any unusual circumstances on the property that justify the variance? I think if we want to make the motion to approve this variance, we should acknowledge some special circumstances on the property that justify it. So if you wanted to base your motion on the existing natural berm, 15 feet of grass off-site between parking and the road, and other mitigating conditions that make these requirements unnecessary, that's the kind of justification I think we'd need to have.
I agree with you, but Henry requires more than that. Okay. And maybe will not adversely affect any public health, safety, or welfare. Does that sound?
If that's acceptable to Mr. Baker? Okay.
Lonnie, is that acceptable to you? All righty. Any other input on that motion? All in favor? Motion carries. Thank you all. Next up, James Durham has applied for an administrative appeal on a notice of violation for an off-premise sign at 461 South 4th Street.
Mr. Chair, the appellant gets to go first in this. I'm just bringing up that since we don't have very many of these, they're taking issue with an interpretation that your director has made, and they're going to present why they think that she's factually or legally wrong. After that, we'll respond and make our case, but you have to decide whether there was evidence supporting Michaela's decision and if she was arbitrary in the way that she applied the law to the facts. So that's the decision before you tonight.
All right. Looks like Chris is here to support Jamie, so we'll let him talk first.
Well, first of all, our appeal isn't confrontational. I mean, we want to definitely do the right thing. Mr. Durham has taken Dillahay Street, which wasn't so nice, and really improved a lot of it to make it nice for our community. And one thing I think that we need to remember with this is that not all buildings have the luxury of being on a major thoroughfare where you can put a sign there, right there, where everyone can see it. Some buildings are in commercial areas where, you need to advertise it to know where it's at. And in this particular situation, the issue is whether or not the sign in question is a on-premises sign or non-premises sign. So I want to read the definition of premises. Premises is a general term meaning part or all of any lot or part of all of any building or structure or group of structures located thereon. So with that particular building, Mr. Durham actually owns the building where the sign is placed that you saw earlier. Also, Mr. Durham owns the building at 498 Dillahay, which is where they sell ice cream out of that building. Well, 461 Dillahay is where the sign in question is located, and it's the corporate office is located for Finn's Ice Cream within that building. And within that, I've talked to Mr. Durham, and within that building, he intends to sell merchandise related to Finn's. We argue that the premises is not strictly the place of 498 Dillahay where ice cream is sold, but the premises is both 461 and 498 Dillahay because business of Finn's is taking place in both those locations. And what's been brought up is with that sign, there's an arrow and it's pointing towards the place where ice cream is sold. Well, there's no rule that you have to just sell strictly ice cream at one place. Businesses sell lots of other things. If they didn't, they wouldn't be able to survive. And that's why merchandise and so forth is just going to be sold there at Finn's Ice Cream. As far as Ms. Gary goes, I mean, I think that, she's looking at the rules or the ordinance as it's laid out, and we just don't agree with her interpretation. People interpret things different. Multiple people in here would interpret the Bible, for example, differently than one. But in this situation, we interpret the ordinance as it is on-premises sign because that building is part of the premises. And I think that the decision would be arbitrary because I want to just give you some examples. Recently, I came back into town, coming down 127. I see a sign on 127 where it's advertising. They're really nice signs. I think maybe the city put it up. Dollhouse, so many miles away. Constitution Square, so many miles away. Well, they're not there at that sign. They're telling you where to go. Is it promoting? It's giving direction. And that's kind of the, what's happened in this situation too. But arbitrary, maybe so. I would also point out there's a local law firm. I really don't want to throw them under the bus or anything, but I believe they've been approved. And on 3rd Street, right before you get to the hospital, say that you're going towards 3rd Street, I think the street's called Jacob Street, and it connects between 3rd and 4th Streets. There's a sign on a lot, which is not part of the whole lot where this law firm is located, because I think one of the law firm owners or partners owns that lot, but the law firm has a different name owning where the law firm is located. Anyway, it says so-and-so law firm, an arrow pointing towards the law firm, which is not on the lot, but it's down the alley, narrow alleyway, and the law firm's sitting there. So I think it's the same deal, and it is arbitrary because if that one can be approved, this one should too. I feel that that law firms is on premises, and I think that this one is as well. When laws are written, you can't necessarily think about every little situation that occurs, but definitely that might arise. But I don't think that anyone, when creating the sign law, was trying to create a law that would put people at a disadvantage who aren't on major thoroughfares to promote their business. Therefore, we argue that it is part of the premises, and we ask that you approve it. And I like how Mr. Baker, on his previous motion, he said, it just makes sense. It's common sense. That's the same situation, too. It's common sense that this is part of the building, and it's doing no harm, no foul. It's helping, it helps tell where people, where the ice cream part is, but also it's telling people this is the building, the corporate office where Finn's Ice Cream is located. And if a modification of that sign is needed, if we need to write in small lettering corporate office or whatever, or buy your T-shirt here, we can do that. But I think it's a really pretty sign, and we would ask that you overrule in this situation and rule in favor of Mr. Durham.
Any questions?
I do have a question. You did say that you own the building where the sign is placed, correct?
Finn's Ice Cream has an office in that building.
Sure, but you own that building facing 4th Street, or 3rd, I guess it's 4th Street there.
Yeah, on that one and the one the ice cream shop is
I do have a question. Is there any law that says that this man can't put whatever he wants to on his house? If he wanted to paint it pink or purple with polka dots, is he allowed to do that?
That would be a question from Michaela.
We wouldn't dictate paint color. It's signs
So-
we have an ordinance on, so we regulate.
And I'm not trying to be
where they
argumentative,
can
I'm
be
just
and
trying to make
how
a point
big,
here.
et cetera.
So
Yeah.
if he painted directly to the brick ice cream shop this way, would that satisfy?
We would still consider that a sign. I mean, I guess if he didn't put the logo and put fins, I might have to consider that. That's a gray area, but,
I
yeah,
think we're getting
in
pretty.
general, if it has a logo or if it's advertising in any way, shape, or form, we consider it a sign, not a mural or wall art.
Okay.
So the mail for Finn's Ice Cream, where does it get delivered? Just, okay. Where do you pay the bills? Where do you pay the bills for Finn's Ice Cream?
We can put a post office there.
I'm just
I
asking.
truly want to do everything
Yeah.
we can to be compliant.
Sure.
I don't want to be home.
Yeah.
So,
I'm just trying to help you.
yeah, I understand.
Yeah.
Yeah.
So,
Can,
hang on a second. Nope, hold on. Any other questions for Chris?
can we go back to the previous, the map?
Yep.
There's quite a few properties in between these two locations. I'm struggling to understand them both as the same premise.
This is,
I know where, I know where it is.
They're two separate parcels.
They're two
the-
separate parcels, there's other
yeah.
properties in between. I'm having trouble understanding that as one parcel, as
Well,
one premise.
I mean, I think the definition of premise, I mean, depends on how you interpret it. I mean, it talks about building or structure or group of structures located thereon. So, I mean, I think that you could interpret it, it doesn't necessarily, I mean, that's what I'm arguing, that it is part, I mean, that's a small street, you know, there's a couple buildings, but hey, he owns actually another one or two of those buildings also on that street. I
What I
think the
was gonna say, you-
self-refines over there.
kind of own a couple of these buildings, don't you?
Right,
I
so,
own everything to this small roof, I own everything to the street forward, so a lot of that's an old picture. There's a whole lot more buildings there now, and then I own this one on the back corner.
Yeah.
And so, I think what I'm saying is that it truly is think about this, if McDonald's owned a McDonald's, and then next door, they had a corporate office on a different parcel, and they put a sign up that said McDonald's on it, I don't think anyone would have a problem with it. Maybe you want me to put corporate office on the sign, but no one would have a problem with McDonald's having two parcels with two words on it. Clearly, the one that sells hamburgers is the one that sells hamburgers, and the other one is not. And so that's for me the argument. They're saying it isn't there's truly Finn's business happening in the building on the corner of Fort and Dillahey, so they should be allowed to have a sign there if they do business there.
if you want to get a job, I mean, apply, I mean, that's where you would go to get a job application, you know, to apply to work for Finn's, so.
My question is the question of, because it's the sign on that building, or because it's just a sign? The sign is not supposed to be there. Because I'm kind of where he's at. If I own that building, I feel like I should be able, what if he puts a sign in his yard and says, that important direction, like, and gives an address? I'm not understanding the reason why he can't put a sign on his own building.
Well, non-premises signs pursuant to the rules are not allowed. So they're arguing it's a it's not on the premises. We're saying, we think it is part of the premises. Is that law or the rules current? Does it need to be changed? I think it does, because, I mean, I don't think it took into, even consideration, you know, some of the things like, oh, this is prohibiting businesses that maybe can't afford to be on the main strip to, you know, to promote their business. So I think that at some point that should be changed, but for today's sake, you know, we're arguing it is the premises. It is part of the premises, and it should be allowed.
So if the sign's not, just say the sign is not allowed to be there, where is he allowed to put a sign? He can only have a sign if he puts it on that particular building, that he actually sells ice cream, or?
If signs that are directing customers to the purchase ice cream should be on the site where,
The actual products are being sold.
right, that's the way the zoning ordinance reads.
But my argument is, you don't have to, just because it's Finn's Ice Cream doesn't mean that that's the only thing sold there. They sell merchandise, they sell what else do you sell? I mean, there's other things besides ice cream that is sold. I mean, you might sell sandwiches, you know, so it's not, you can't just say it has to all take place in that one place on 498 Dillhay. It's all in the same.
Jim, you have a question?
Well, I have as much a comment as it is anything. Section 3.6.4 of the zoning ordinance says that our board can only overturn Michaela's decision if we deem her decision to not be supported by substantial evidence, or that it be arbitrary and capricious. And I too have trouble with the idea that there are intervening parcels between the two buildings. If they want a sign at this other building on the left about Finn's Ice Cream, they can put Finn's Ice Cream corporate office if they want to. But they clearly, in my judgment, do not meet the requirements as an on-site sign.
Mr. Chair, at this point, I think I want Chris to get all the time that he needs to make his case, and then I'd ask for a chance to respond in brief.
Yeah,
I mean, that's why we're here today.
yeah.
Definition of premises versus non-premises. I mean, Michaela, she's great. I mean, I work with her in my other job, and she does a great job. We can agree to disagree, though, on some things, and that's why I disagree on this situation. It is arbitrary because, like I mentioned, the other signs that are having directional, telling you where to go or whatever, when the place is not at that particular spot, that's why it's arbitrary. It's arbitrary to choose to say this one's wrong and this one's not. You know, if one's been approved, it is arbitrary. And she probably wasn't even around when that actually was approved or not, but the law firm I'm talking about, but that would be arbitrary to allow one and not the other.
Okay. Any other? Sure.
I guess I would go by the old adage that one wrong doesn't make a right. If you know, if the law firm
Hang on,
sign
Jay.
is in violation, then we can address that as a violation. But it doesn't seem to me that it's an excuse for the Finn's ice cream issue.
Right. We're not looking for excuses. I'm saying the law firm that's their premises as well, and they're in compliance with the law, the statute or law or ordinance. So no way am I throwing them under the bus. They're conforming, and we are too.
Any other questions for Mr. Herron?
It's just more of a comment. I mean, I can think of countless other examples. I mean, in Parable, for instance, when you're pointing towards Merchant Row, there's 5 or 6 businesses right there on the corner of 68 and Highway 150 that's pointing to all those businesses that they don't even own that parcel right there. So I don't see the problem with it. I don't. I mean, you're trying to help this guy's business. I understand the law reads this way, but you can't let one do it and not let everybody else do it.
I think we have, when is public comment? Is it
After-
after you go?
I'm
sorry.
We're going to let our attorney
Yes.
speak,
Yes.
and then we'll open the floor for public input after that.
Thank you.
Yeah. If you're done,
I'm done. Yeah.
okay. Thank
We're just going around in circles.
Thank you. Yeah, it just seems to be. Henry, if you would take your
Thank you.
turn now to
I
address
think
this.
that Mr. Herron and Mr. Baker are right to talk about common sense. This board is convened in order that you all might bring common sense to the situations that are presented to you. When they're presented to you, that's your staff applying a rule that's in the zoning ordinance. And this board is bound by its zoning ordinance. It has to enforce it. It cannot act in a way that the zoning ordinance does not condone. The rule that we're bringing to you today is that off-premise signs are prohibited throughout Boyle County. And off-premise signs are signs that identify or direct you to goods or services that are not conducted, sold, or offered on the premises where the sign is located. So if it's sign on one site that says, go down the road to get your fried chicken, that's not permitted. The sign should be at the fried chicken place. I'll remind you that the standard that's brought to you, which I thought Mr. Brown's point was well taken, is that your questions are, did Michaela use evidence, and was she arbitrary in her application of that evidence? You know, did she read the rule correctly, and did she have the facts to back her application of the rule? Sometimes arbitrariness is talked about in terms of selective enforcement, and I guess at this point I want to direct one or two questions to Ms. Gary. How did this matter come to your attention?
We received a call complaining about the sign, so when that happens, I go out and investigate. So I drove out to 461 South 4th Street, saw that the sign was up, that was promoting Finn's Ice Cream, which is down on 498 Dillahay Street, so at that point, I sent the notice of violation.
If you had received complaints about other off-premise signs, what would have been your approach in investigating those signs?
Same exact approach. That's how we address all complaints, is we go out and investigate, and if I feel I have enough evidence to produce a notice of violation, that's what I do.
We have a small staff, and what we do is often driven by the applications or the public comment or complaint that are brought to us. That's pretty much the only way that we can operate. Dr. Miles pointed out that there are other lots in between. I appreciate reaching to the definition of premises. I think that's a point well taken, but I think where there are intervening lots, I would suggest to you that that's not considered part of the same premises, and to read it as such would be against the spirit of this rule. Ms. Gary, what would be a reason for a ban on off-premise signs? I didn't ask you that beforehand, but
Yeah. I mean, I don't want to read too much into it. There is a blanket ban, which in my mind reads, we can't issue any variances or anything of the sort. So legislative bodies are the ones that adopt these zoning ordinances. It's first brought by Planning Commission, so I think there was buy-in from all four legislative bodies that they did not want to allow for off-premise signage. It's very clear. It's just one sentence. There's no exceptions, nothing. It's just no off-premise signage. My guess is that it just limits the amount of signs that could be put on a property, billboards, et cetera. But I obviously didn't write the ordinance, so I don't want to say too much about the intent, but.
this board is not brought here tonight to comment on what is a fine, attractive-looking sign, but one reason for the rule might be to limit the use of public space for commercial purposes and not have every square inch of public space covered up with signage or advertisements. But again, that's not the question that's brought before you tonight. The question is, did Michaela have the facts at hand? And there are not many of them. There's a sign in one place, and the thing that it's directing you to is around the corner. Did she have those facts, and did she correctly read the rule? I would suggest to you that she did. Ms. Gary, in your opinion, is the sign in question directing customers to purchase merchandise, submit job applications, or otherwise conduct business at South 4th Street?
No,
And-
I feel that the sign is directing business to 498 Dillahay Street.
And what causes you to think that?
The arrow and, yeah, primarily the arrow is what I would say. But
If this is truly a case of something that's not causing any harm, then that's maybe a good opportunity to talk about amending our zoning ordinance. That's a discussion for another time. I think at hand we have a clear violation of a bright line rule, and I would ask you to uphold your director's findings.
Is there a variance process for this off-premise sign?
No.
There's not.
Because it's expressly prohibited, the board does not have the authority to grant a variance on
Okay.
something that's expressly prohibited in the ordinance,
Right.
so.
I have a question. We use the word corporate building. If he would happen to add that to that sign, would that sign be able to stay there? Or that sign would still have to, by law, by the rule, that sign has to be removed regardless?
I think you heard your director say that there's an arrow directing you down the street, and that's kind of the substance of it, what makes it a sign directing you elsewhere than that building. It,
So yes,
I think there's room for interpretation on that, with the corporate offices if the arrow were removed.
Any other questions? Henry, is that the end of your input?
I think if there's any public input, I'll ask for 30 seconds to talk after this, and then Chris gets the last word of rebuttal.
All right. Yes, sir. All right, at this time, I'll open the floor for any input in support of Mr. Durham.
Hello, my name is Jason Cullen. I'm a magistrate for the 4th District. I was kind of brought in on this topic, which is interesting because we've been talking about it in other circumstances. I'll be the first to admit when we change ordinances or we change things, we don't always get it right. There's things that tend to get missed. I think the zoning ordinance that we did was a huge step forward for Boyle County. I thought it was great, but there's some things that we obviously missed. One of the things that we missed was, or the way I'm looking at it is, when you had mentioned 2 wrongs don't make a right, what happened was previous to this change of the zoning ordinance, there used to be a 2-tier law in there where businesses that were off the street had the ability to actually have a sign placed out towards a major road. And that's where we're seeing some of these things. The law firm, I can tell you another one is the Red Roof Inn out over off 127, 150. Right there up front, there's a small little sign that directs you to the Red Roof Inn because it's pushed far back. And so I'm not asking to completely overrule this whole situation, but maybe give us an opportunity to make it right. I think that it's inherent, especially when we're a smaller community that does have businesses off the side. Not everything's on Main Street. So I've actually asked Michaela already to start the process of coming up with a new variance of the sign ordinance. Now, this is in the city limits, so it's technically out of the fiscal court's purview. We'd have to have buy-in from the city as well. But I've talked to a commissioner as well who kind of feels that kind of same way I do that this is a semantic. I understand why we may have some of these, but a lot of the planning and zoning ordinance that we currently have was brought from a previous county, from the previous planning and zoning director. He kind of brought some of what they did there here, and I don't think we maybe saw all of that was in there or didn't think about it. And so my ask is that before we, make Mr. Durham take down this sign, I know it's already been tabled once, and I don't know, I'm just going to have to go back to Henry or whoever to see about possibly, instead of taking down the sign right now, making any extra expenses to Fins or Mr. Durham, maybe you give an opportunity to Planning and Zoning, Fiscal Court, and the City Commission to possibly look at redoing the signing ordinance. That would be my ask. So, thank you.
Anybody else care to speak in support of Mr. Durham? Anybody here that would like to speak against Mr. Durham this time? Henry, I'll give you a chance at.
This board is sometimes described as being a safety valve for any hitches in the zoning ordinance or ways that they butt up against the circumstances on the ground. And that's a chance for you to exercise your common sense. But that safety valve mechanism is through variances and conditional use permits. I would suggest to you that this board is bound by its zoning ordinance, and there's an ongoing comprehensive plan update right now, which might be an opportunity to amend that zoning ordinance. I think that's what the magistrate was referring to. But I think with the facts before you, I would ask that you deny this appeal and incorporate the findings that I've provided to you. If you should wish to pursue the magistrate's suggestion, I do think that you would be permitted to hold this in abeyance or table it.
And just a second, a question for Michaela. If we tabled this, what kind of time frame would we be looking at for this to be brought up and maybe amended?
To be quite frank, I'm going to be out of town for 2 weeks coming up here shortly, so I probably wouldn't be able to get a sign ordinance together until the September Planning Commission meeting. I just think it'd be too quick of a turnaround for me to meet with the appropriate parties, do necessary research, et cetera, until the September meeting. If Planning Commission were to take action at that September meeting, then legislative bodies have 90 days typically from that point on. So, I mean, realistically, it could be it could be 3 months, it could be 6 months.
Right.
It's hard to say. Ordinance changes are a lengthy process, so. Yeah. Typically for an ordinance amendment, it would go through 2 readings, so it'd at least require 2 fiscal court meetings. So City Commission likes to do 1 preliminary meeting and then do 2 readings, so they take 3 City Commission meetings to do it.
And if we did table it tonight, would Mr. Durham be required to take any action until we untable it and bring it back up again?
I think that we've been interpreting that enforcement of this and, you know, anything that we would do to try and force the sign to be taken down is told and stopped by this proceeding. So I think there's room to say that it would pause enforcement if you did vote to table it.
If it's denied, when does the sign have to be down?
We would likely work with the applicant and give them an appropriate time window, 30 days or something of the sort. Board of Adjustment is free to assign that date if they want to. Otherwise, I usually work with them and give them appropriate time to do so.
I would think that Dillahay is, for all intents and purposes, a dead-end street, and it would be hard to, for somebody that's not familiar with his business down there to be able to find it, because they wouldn't go down that street just to be driving around town. They'd have to seek it out. So I do see where it is pretty necessary to have that there. And instead of just making a decision one way or another on this, may be a good idea to just table this, see if you can work with the legislative body, make a variance process for an off-premise sign, and then look at this in a couple of months.
It seems to me we have the evidence in front of us. I don't see a need for a tabling.
Yeah. I will let Chris speak, and then we will deliberate then.
I mean, I like, Mr. Sutherland, how you're thinking outside the box to try to help a local business out. You know, this could be taking that sign away could be the difference between, you know, it even being around by the time that the fiscal court or anybody can meet to try to change it to make the law or the ordinances better for what you say off-premise sign is. I think you have the opportunity, you know, I say use common sense. Well, yes, you have to go by the law, but I think with my common sense that I'm using, I feel what you could even do today would be, common sense would be these 2 buildings are the premises, and therefore it is not in violation. But on the other end, if you do not choose to do that, then it's better than nothing to have a table, and that will get us through the summertime where ice cream is very popular, and that would help. It would help. Anything would help, so.
I don't like it at all, but if you got common sense in the law, 99.99% of the law is gonna win. So I'm at the point where, you know, I don't like it, I understand their side, but it's kind of hard to go against what's on black and white. So back to what he said, I don't see the reason why we even table it. I mean, Taylor is just putting it off, prolonging the inevitable.
If we table it, it may give Michaela a chance to work with legislative bodies in town, in the county, to create a variance process for circumstances like this. And I agree that Henry has spoken that we don't want every building in town plastered with signs pointing people to other businesses. But just like there are variances and conditional use permits for other circumstances, ordinances, there may be a need for one on this. And if we vote either for Mr. Durham or for planning and zoning, then this is basically dead at this point, and there's no reason to pursue changing the ordinance. So that's the choices that we now have to make. We either shoot down his sign, we agree with him and allow the sign, or we table this and let Michaela work to maybe fix this ordinance.
Did I hear him correctly, that you said that we could not overturn her ruling? You said that earlier.
This is presented to you tonight because we can't close the door to that. They're permitted to bring this up to you and disagree with it. It's my analysis of this that you're bound by your ordinance and that your ordinance says no off-premise signs. Does that answer your question? Okay. Again,
Mr.
I don't,
Chairman, could I interject? Have you closed the public hearing?
Anybody else here to speak for or against? I think I'd done that, but if not, then public hearing is closed and we are now in deliberation.
what I don't want to do is nullify these proceedings tonight and tell you that you have to do what we're saying, because if that was true, then there would be no reason for this hearing. They're permitted to bring this question forward, but it's my analysis that with everything before you, the suggested result is that you should uphold your director's findings. I don't think that you are prohibited from overturning them, but I think that the weight of the facts and the law support those findings.
Am I allowed to say anything else, or is it done? I don't want to.
Yeah, we're done with
Okay.
input. Thanks, Chris. Mr. Aaron. Deliberation?
I read the ordinance. There was a reason, when the ordinance was developed, there was some reason for distinguishing between on-premises and off-premises signs. And I can imagine, what those good reasons might have been. So we have that ordinance in front of us. The argument that this is one premise, although they're separated by a couple hundred yards and other property owners, I don't find that convincing. I don't find any evidence that this is capricious or willful. It seems to be a legitimate reading of the ordinance as it's written. So I'm going to suggest upholding the decision.
So my take on it is that for other sign issues that pop up, there is a variance process. If somebody,
No,
if somebody comes up and has a sign in front of their building, and they're only allowed to have a sign that's so many square feet, but they want the sign to be larger than that, they would need to get a variance.
Yes.
And what I'm trying to say is, I think that for this, there should be a variance process. There's not, and I think that the rules should be changed to allow a variance process. And if we table this and let them make that determination, and we come back and look at this in a few months, giving them time to do that, then he may be able to do a variance process and get approved. If we shoot it down now, then he's got to take the sign down, and he's out that money. Yeah, it's,
Well, I don't know. The most recent time that I remember when an off-premises sign was rejected was for the Best Western Motel. And they asked to have an off-premise sign on the bypass, and that was denied. And I think the evidence is clear that the staff has properly interpreted the ordinance and that we should uphold the decision of staff and make the findings that the decision was not arbitrary and that it was based on the substantial evidence. And I would make a motion to that effect.
Any other
I will
input?
second that motion.
okay. We have a motion and a second to stand with the decision as made.
Can he clarify where the Best Western is? Because we don't have a Best Western in town.
He said in the past.
Huh?
He said in the past.
In the past, yes.
Any further discussion on it? Just to be clear, a yes vote would be denying his appeal. A no vote would be in support of the appeal. So-
Our IT guy's gonna go turn it back on. We knew this was coming. I apologize. Yep.
Say that again, I got confused.
A yes vote would be to support Michaela's findings.
To sustain, okay.
Yes. A no vote would be in support of Mr. Drum.
Agreed.
So all in favor?
Aye.
All opposed?
We need you, Lonnie.
All on you vote. Okay. Motion passes 3-2.
Okay, good.
So, I don't know if, we could be back here because, what's gonna happen next is we're gonna put corporate office and I'm gonna put an arrow that's pointing down to that and leave the arrow that's pointing that way. So hopefully that might be suffice.
I would just recommend working with Michaela on a solution in the interim that'll. Yes, sir. Thank you. Next item is Angela and Roy Martin have applied for an administrative appeal of a notice of violation for a short-term rental at 3035 Waterworks Road.
Good evening. My name is Bethany Baxter. I'm here on behalf of the appellants, Angela and Roy Martin. Let me get set up real quickly, if you would. I've got a couple documents I wanted to pass out. I've provided these to staff and to Mr. Smith before the hearing. One of these is an affidavit, but I only have one signed copy. They're all the same, but I just asked that the signed copy make its way into the record. Grab one of those too.
Sure.
Thank you.
Can have that one.
And these are some proposed findings of fact conclusions of law.
Okay. Pass me back one, Steve.
Oh, pass her back one.
Yeah, me.
You back.
I gave her mine.
Okay, well, I'll go ahead and get started while those documents are making their way around. As I said, my name is Bethany Baxter. I'm an attorney here on behalf of the appellants, Angela and Roy Martin. And just to give you guys an idea of who the Martins are, Angela and Roy moved to Boyle County back in the late 1980s, and they actually bought a farm at 450 Waterworks Road. They moved here to raise their family. They owned and operated a family business here, Martin Insurance, for decades. And while they spend a lot of their time down in Florida with their kids and their grandchild, they still call Waterworks Road home. So the Martins purchased 3035 Waterworks Road, which we're here to discuss tonight, in approximately 2009. For a significant period of time, they rented the property out to long-term tenants, and then in approximately late 2016, they started using the property, renting it out on a short-term basis. Roy and Angela themselves actively managed that short-term rental for a number of years, and then later turned that responsibility over to Connie Privet, who's here in the back of the room. She also lives on Waterworks Road, and she drives by this property every day. If not, going inside the property, the neighbors know her, and they should know that they can come to her with any issues that might arise. The affidavit I passed around, I believe, are facts that are not in dispute, but I wanted to get those in the record, and that affidavit is from Ms. Privet. So I understand this property came to the attention of planning staff via some complaints from neighbors related to another short-term rental on Waterworks Road that I understand recently came before this body seeking a conditional use permit. I want to point out that 3035 Waterworks Road is substantially different from that property. 3035 Waterworks Road has been operated as a short-term rental since, as I said, sometime around late 2016, prior to the amendments to the Boyle Danville zoning ordinance that incorporated some requirements and regulations on short-term rentals. And that's a very important distinction for purposes of considering this appeal, because the Martins' use of 3035 Waterworks Road is a non-conforming use, and the planning staff erred, respectfully, it's our position, they erred in finding that my client's use of this property was not a valid non-conforming use under Kentucky law and the ordinance. So what is a non-conforming use? I'm just gonna take a moment to reflect on that. A non-conforming use under Kentucky law includes any lawful use of a building or premises that existed at the time of the adoption of any zoning regulation affecting it, and such uses may be continued even though they don't conform to the provisions of such regulations. That's the situation that we have here. Non-conforming uses are sort of well established within Kentucky law. I'm going to quote some from the Kentucky Court of Appeals. Loss of a vested property right in a non-conforming use is capital punishment in economic terms. Also from the Kentucky Court of Appeals, a non-conforming use is a property right constitutionally protected. Again, the Kentucky Court of Appeals, while a non-conforming use may be deemed to be undesirable by a portion of the community, it nonetheless constitutes a legitimate vested property right and clearly enjoys broad constitutional protections. The Sixth Circuit, interpreting Kentucky law, has also held the right to continue a non-conforming property use is a vested property right. It is not a personal right, but one that runs with the land. And that has been my client's understanding of their use of this property since the passage of that 2020 changes to the zoning ordinance. I'd also note that my client's understanding is consistent with what they were hearing from the planning staff back in 2020, close in time to when these amendments were made. So these are some emails that are also attached to my letter that you got previously and I think got passed out with the packet of information that went around earlier tonight. Jacob Martin is Angela and Roy's son. He also helps manage these properties. He asked planning staff back in 2020 whether or not this grandfathering concept for short-term rentals would survive, a change in ownership and so forth. And he was told that so long as the use does not cease for 12 months or more, the grandfathered non-conforming use will be allowed. That was consistent with his understanding, his reading of the ordinance, and also what he was hearing from planning staff some 4 years ago. This is another email also included with the materials I provided. This one's a little interesting because I think planning staff believed the Martins to own and manage a property at 515 Tennicket, which I understand to be in town. They don't actually own or manage that property, but that email also from back in 2020 made clear the planning staff's position, which is that an Airbnb use of property is grandfathered in. So that interpretation changed substantially recently when my clients were advised that it was the planning staff's position that their property was not lawful and did not enjoy this non-conforming use status. So in April of this year, they were first told that that their property was in violation. They had to get a conditional use permit consistent with the 2020, currently controlling ordinance. And then after seeking some sort of additional information about what's your basis for taking that position, they got this letter dated May 16, which provided as follows. So the Martin short-term rental, which has operated for about 7 years, can only continue as a valid non-conforming use if it was a lawful use under the previous zoning ordinance. I would agree with that. That October 18, 2024 ordinance, which was the one in effect at the time that they started using the property as a short-term rental, that ordinance provided for a conditional use permit being required for a bed and breakfast in the AR1 zone. That's true. If you look at the ordinance, which I've attached to my letter, that's what it states. There's also a provision in this section 5.2.1B10, which says that a property owner also has to get a conditional use permit if they're conducting any other use that's determined by this board, the Board of Adjustments, to be of the same general character as any of these previously listed specific uses. And so it was the planning director's determination that the Martins should have, back before 2020, gone to get a conditional use permit because their property was of the same general character as a bed and breakfast, and therefore has been unlawful all this time. And I just want to pause. Michaela, would you agree with my sort of assessment of your determination in that letter?
Yes.
Okay, thank you. I have one more question for you, if you don't mind. It's my understanding, I think you told me earlier this week, this is the first time that planning staff has taken this position as to a short-term rental that existed prior to 2020. Is that correct?
That is my understanding. It's certainly the first time since I've been on since October 2022.
Okay, thanks for confirming that. Okay, so really what is bearing on this decision tonight is, was the Martins' property back in 2017, 18, 19, was it a lawful use or was it an unlawful use? If it was lawful, it enjoys that non-conforming use status through the amendments that occurred in 2020. Okay, this is so from the 2004 ordinance in the AR1 zone, which is what 3035 Waterworks Road was zoned for. Uses permitted by right included a single-family detached dwelling, whether related to a farming operation or exclusively residential, on a minimum lot size of 1 acre. I'm going to come back to that later, but I'm going to sort of footnote that for now. Uses that were permitted by condition, as Michaela said in her May letter, would be something like a bed and breakfast or something determined by this body to be of the same general character as a bed and breakfast. So then it begs the question, how did the 2004 ordinance define bed and breakfast? A bed and breakfast under the 2004 ordinance was specifically defined as an owner-occupied house or portion thereof where short-term transient lodging is provided, including serving only a breakfast meal to overnight lodgers. I'm going to skip down, and you'll see the other highlighted portion there. The ordinance clearly contemplated that a bed and breakfast facility was a type of building that was rented out by the room by room. The other place that bed and breakfast facilities are discussed in the 2004 ordinance is in Article 7, which talks about uses permitted by condition as to bed and breakfast facility shall be owner occupied, and a bed and breakfast facility shall have no more than 4 rooms for rent. So that's the ordinance definitions and language that we're working with to figure out, was the Martins property a bed and breakfast or something of the same general character as a bed and breakfast or not? And it's kind of a darker picture, but I would submit to you that it is not. The Martins have never lived at 3035 Waterworks Road. Neither has Ms. Privet. They do not rent this house room by room. It's rented out on a house-wide basis. They've never offered meals, breakfast or otherwise, as part of that rent or stay. And this is a house with 5 rooms, more than the 4 that is permitted under the 2004 ordinance. And I don't think that the planning staff disputes any of those facts that are also kind of confirmed in Ms. Privet's affidavit. But am I correct that, do you have any reason to believe that the Martins lived there, it was rented out room by room, that it's less than 5 bedrooms, or that they offered meals as part of the stay?
No.
Okay,
I have a question.
sure.
You said this is not a bed and breakfast, so what would you label this house? What would this be called?
Yeah, so I'll get to that, but I would, it clearly meets the definition of the single-family dwelling. And I've got those definitions. I'll show them to you in a couple of slides here. So I just want to pause here too. The Martins had no reason to believe, based on that 2004 ordinance, that what they were doing was operating a bed and breakfast facility or anything in the same general character as a bed and breakfast facility based on those definitions in the ordinance itself. I want to note too that the Martins, they, at the 450 Waterworks Road where they have a farm, they have operated a bed and breakfast there. And that was a building where they rented out by the room. The Martins cooked folks breakfast, and they got all the permits that were required for that bed and breakfast, as well as a special event center permit and a retreat center permit. So these are not folks that are trying to shirk the rules. These are folks that, as you saw in this 2020 email correspondence, folks that were trying to make sure they got it right, check with folks, and it has always been their understanding, based on the ordinance and their communications, which bolster that understanding, that short-term rentals were not considered a bed and breakfast or something of that same general character. So I want to talk specifically about 5.2.1B10. That's the specific part of the 2004 ordinance. Any other use that is determined by the Board of Adjustments to be of the same general character, that kind of catch-all provision. What I've got up on the slide here is KRS 100.237, which is part of the statutes that governs or controls, I guess, how this board functions and what sort of the authority of the Board of Adjustment includes. This board has the power to hear and decide applications for conditional use permits for uses which are specifically named in the zoning regulation. And I would submit to you this sort of catch-all, anything that walks and talks like any of these other specifically named things, is not something that is specifically named in the zoning ordinance, and that sort of catch-all is impermissibly vague and fails to comply with this statute. The other sort of big issue with that is that the Board of Adjustments has never determined the Martins property to be of the same general character as a bed and breakfast facility. That my clients have never been made aware of that. I don't know that, Michaela, are you aware of the Board of Adjustments ever deciding that the Martins property was of the same general character as a bed and breakfast?
They did not have an application for the BOA at that location.
And you're talking about ever in the history?
Yeah, we don't have any, I apologize. My mic's on mute, I'll repeat that. We don't have any record of them ever applying for any type of conditional use permit of that nature at 3035 Waterworks Road.
Okay,
Under the applicants. Yeah.
So it's really only the planning director that's taken the position that this is something that is of the same general character as a bed and breakfast facility, but that's not what the ordinance provides for. The ordinance provides for the Board of Adjustments to make that kind of determination, and the Board of Adjustments never made that determination under the 2004 ordinance, which has now been replaced by the 2020 ordinance. For those reasons, I believe that the planning staff's determination that my client's property was of the same general character as a bed and breakfast, and thus should have sought a conditional use permit, and thus is an unlawful use, that is not supported by substantial evidence of record, and that is an arbitrary and capricious determination. So back to Mr. McGuire's question. As on that previous slide, I noted that a use permitted by right within the AR1 zone back prior to 2020 were single-family detached dwellings. If you look at that 2004 ordinance, the definitions of dwelling and dwelling single-family detached are very broad and all-encompassing. A dwelling is defined as a building or structure which is wholly or partly used or intended to be used for living or sleeping by one or more human occupants. Similarly, the single-family detached, dwelling single-family detached, that includes anything, so long as it's a residential building containing not more than one dwelling unit located on a lot containing no other dwelling units. These definitions from the 2004 ordinance are sufficiently broad to encompass all sorts of scenarios. A scenario where the owner lives in his own home, a scenario where the owner rents their property out to someone for a period of a year or a month or a day. There's nothing within these definitions from the 2004 ordinance that limits a property owner as far as rentals or any sort of period of time. So the Martin's use of 3035 Waterworks Road as a short-term rental beginning in late 2016 or early 2017, whatever the case may be. My client's recollection, it's late 2016. But regardless, that is a valid non-conforming use under Kentucky law and under the only reasonable interpretation of the zoning ordinance as it existed back in 2004. So again, I just asked the Board of Adjustments to find that the planning staff's determination that there's been a violation here, that is not consistent with the ordinance, Kentucky law, and is not based on substantial evidence, and is otherwise arbitrary and capricious. So I'm happy to answer any questions, and I'll look forward to an opportunity to respond later.
Any questions for council? All right. We're good right now?
Okay, I know I threw a lot at you, and it's kind of in the weeds, so I was hoping the PowerPoint would help, but thank you.
Thank you. Henry?
Thank you, Mr. Chair. I'm going to point you back to what's being asked of you today. Did Michaela have facts before her, and there were not many of them? And did she correctly apply the law to the facts? The relevant facts here are that this is a property that's in the county, that there was no conditional use permit at any time permitting any use other than a single-family dwelling, and that there is currently the operation of short-term rental on that property. That makes it a violation. The way I understand opposing counsel's argument is that this use is grandfathered, that it was previously lawful as being permitted as being a single-family dwelling, and we disagree with that characterization. They rely on statements that seem to come from prior director Steve Hunter. It was maybe his interpretation that short-term rentals, if they weren't mentioned in the zoning ordinance, if they weren't regulated, and there is impending regulation, to speak colloquially, anything that comes in under the wire can continue to operate. But he was relying on the fact that it wasn't regulated previously, and it was. There was nothing that permitted it. There was a regulation that set out the uses that were permitted in this zone, and it did not list short-term rental or any kind of commercial lodging setting as a permitted use, except with a conditional use permit. This question before you today hinges on the idea of a lawful use. We would submit to you that it was not a lawful use. The zoning ordinance names what the permitted and conditional uses are. If a use was not named, if short-term rental was not named under those uses, then it's not permitted. Arguably, we could shoehorn it in there with bed and breakfast or a conditional use permit that brought in something that was of the same character as other uses listed in that zone, but the Martins did not obtain a conditional use permit. Ms. Baxter presented you with statements from the courts talking about non-conforming uses and the property rights that attach to those, but the court statements are subjugated to the statute, and the statute creates a specific way for looking at non-conforming uses. And the statute favors the gradual elimination of non-conforming uses. There are two ways you can have one. One is that you have a lawful use before there's a zoning ordinance, and it continues after that zoning ordinance is implemented. The other way is you have an illegal use that continues for 10 years without any enforcement action against it. We have the affidavit saying that this use was not existing for 10 years, so we can get rid of the idea of an illegal use that persisted for 10 years. But do we have a lawful use? No, we do not, because there was nothing that permitted it. It was neither permitted of right, nor was there any conditional use permit to support it. I want to point out to you that it's not essential to our argument that this use be classified as a bed and breakfast. Ms. Baxter demonstrated ways in which this is different from a bed and breakfast, that we don't need to convince you that it was a bed and breakfast. We were trying to imagine what possibly could have permitted a short-term rental under the previous zoning ordinance. Arguably a bed and breakfast, arguably the catch-all provision. And I agree with Ms. Baxter that the catch-all provision is really unsupportable, and that's the reason it's no longer in there. Ms. Baxter's position is that a single-family dwelling justifies the use of a short-term rental on the property. Why does a single-family dwelling not include a short-term rental? I think this is where you can engage in common sense. I think this is where you can acknowledge that a single-family dwelling is a dwelling place for a family. There's no reference in that broad definition that you saw earlier to a commercial use on the property. There's no discussion there's no discussion of transient lodging accommodations. And the definition of hotel in that prior zoning ordinance does talk about allowing for transient lodging accommodations, people who come and stay for a little while. The fact that the drafters of that zoning ordinance put that in the definition of hotel, but did not include it under single-family dwelling, I think you can infer from that they were talking about the traditional meaning of single-family dwelling. And so it's based on that we would say that single-family dwelling does not extend to a short-term rental use. There's a lodging summary table in that.
Hey, Bethany. Bethany, can I get the clicker? Oh. Do you care?
Ah.
I'll put that up for you all. Thank you.
This lodging summary table comes from the previous zoning ordinance, and it maybe contemplates shorter stays. But if you look on there, multifamily dwelling, you still had to stay for at least 7 days, and single-family dwelling is not even on there. So I think there's plenty of evidence to show that single-family dwelling is just that, a place for a family to live, and that otherwise there was no permission for short-term rentals in that zone. There was no conditional use permit, and so this was not a lawful use before, and thus there's no grandfathered non-conforming use that survives the revision to the zoning ordinance. Ms. Gary, is there anything you'd like to add? Is there anything that?
No, I mean, I can take you all through my thought process a little bit with the bed and breakfast. Airbnbs are not all like for like. Some are owner occupied, some are single room rental. This one happens to be non-owner occupied, whole house. So I was going in with a little bit of that. Also, we basically regulate short-term rentals as under 30 days, but as you can see, for multifamily dwelling, I think we can extrapolate from that for single-family dwelling that they at least required a week-to-week rental for single-family dwellings or for multifamily dwellings. I think it was a little harsh to classify it as a hotel, which would have been completely prohibited within that AR1 zoning district. So I thought bed and breakfast kind of provided that smaller scale transient lodging that you see with a short-term rental, which was a conditional use within the AR1 zoning district. So I thought it was appropriate with that catch-all, which I have just learned is inadmissible, but that's what I was thinking at the time, is that I thought it was similar in scale and likeness to a bed and breakfast, and so it would have allowed for the board to make that interpretation if they applied for that conditional use permit, to see if they felt the same, that it was something that could be considered a conditional use permit, and then is it appropriate at that specific location, as you do with conditional use permit. So that was my thought process with it. Are there any questions on that?
Yes, this area, let's see, does it permit businesses being ran in this neighborhood?
No, I've got a list. So these are uses that are permitted by right within the AR1
Under
zoning.
the previous
regime.
ordinance.
Yep, under the previous ordinance, sorry. Uses permitted by condition. That's my bad. There's uses permitted by right. I was a little horrified by some of those I saw there, so I'm sorry. So you can see, I mean, it's a lot of agricultural or agricultural adjacent, like kennels, vet clinics, single-family dwellings, school, churches, utilities, recreational facilities, home occupations, tenant housing, horse training tracks, manufactured housing. So nothing really as far as commercial. I would say the commercial aspects of these are all agricultural related uses. I think that continues in our ordinance today. And then uses permitted by condition. So this is something that would have to come before the Board of Adjustment for approval. So you can see here, the bed and breakfast, and then here's that language that is inadmissible, but any other use that's determined by the BOA to be of the same general character. Yep. Yeah, obviously, this is a smaller lot. You know, I don't think it's quite an acre, but, you know, the use of a single-family detached dwelling would be grandfathered. You know, it's a legal lot of record, even with the minimum lot size of 1 acre. But again, I don't feel that the use they're describing in the short-term rental would meet that definition.
So they've been in operation for 7 years or so. What was the catalyst that shone a light on them to have you look into this?
I received a letter of complaint from the neighborhood. It was signed from the neighborhood. We had received a few other calls and emails since then. So just, you know, general complaints, and I saw the listing on Airbnb. I went out and looked at the property and took enforcement action after I reviewed the 2004 ordinance. Like Henry said, you look at those two requirements. If it had been past 10 years, I wouldn't have taken action, but because it had only been roughly seven, I saw reviews on Airbnb back to 2017. An adjoining property owner called me and told me he remembered moving to his property on 2017 at some point in 2017, and he saw the transition from long-term rental to short-term rental. And that's the applicant's memory as well. So we might not have a specific date, but it's certainly not that 10 years. So I felt comfortable trying to review whether I felt it was a lawful use from the 2004 ordinance, and I've laid out my thought process on why I do not think it's lawful.
Henry, do you have anything else to add there?
Not at this time.
Okay. At this time, then, I will open the floor up to public input. I would like to say that I'd like for you to limit your input to 3 minutes. And when you come to the podium to speak, just like you to give your name, address, and just tell us that your testimony is truthful to the best of your ability. And I would like to open it up first to people who are specifically against the Airbnb on 3035 Waterworks Road.
Good evening. Thanks for having me again. We've been here 3 months ago. I think I lived 20 years where I was at before and never attended one of these. So anyway, thank you for having us. My name is Scott Riggs. I live at 2885 Waterworks Road. fairly recently, just 1 year ago that we moved there. I am against this. You know, I would, of course, agree with Mr. Smith's assessment wholeheartedly. One of my arguments is they didn't file for conditional use because that didn't give us an opportunity, or the people at the time, the opportunity in the neighborhood to come through this forum and have a debate about it. The Pikes, who were, you know, basically denied the application to, you know, have their house as an Airbnb. The neighborhood is so passionate about that, not against the Pikes, but just against the Airbnb per se. There was a reason why the neighborhood was so passionate, and that's because of this house, which has seemingly no control over, you know, the people that stay there, the amount of people that stay there. And so that's why there was some passionate, you know, nays against the Pikes having theirs, because we didn't want the same situation that goes on with this house every week. I literally ride my bike on our road, the entire road, every single day, and walk my dogs every single day. And there have been times that I've counted 11 vehicles in this driveway of this house. If it's a 5-bedroom house, it just blows my mind that there's that many people in there. It's an accident waiting to happen. You know, one story is they had some people from Idaho staying there. This is true, and I testify that my testimony is true. And they'll drive 40, 50 miles an hour down our street. And, you know, there was specifically like a Honda green CRV from Idaho that would just drive that road every day for like a week. And, you know, we have winding roads and curves, and, you know, there's times when you can just tell people see you, and then there's times that they aren't paying attention. And so that's just my personal story. I think other people are here today that have lived on Waterworks Road a lot longer than I have. They can attest, going back 7 years or however long this has operated as a short-term rental, even more stories. But I am completely against it for those very reasons. I think it's a dangerous situation, an accident waiting to happen with as many people as they seem to rent this house to, as far as a capacity. I don't know if they have standards. They aren't on site, which I think they lose control on who they are renting it to short term. And so I think that just makes it even, you know, more of a accident or a dangerous situation waiting to happen. So anyway, thank you for your time.
Thank you. Anybody else?
I'd like to hand you off just pictures passed around. My name's Jacob Pike. You might remember me from the last time. We'll have to start selling tickets if this keeps becoming a thing. But all jokes aside, I live next door at 3015 Waterworks Road from the property at hand. I've lived there since 2020. I've just given you all some pictures documenting multiple occasions where guests at 3035 have not followed the statutes and have caused disruption and disturbance to the neighborhood. I'm here to address those ongoing issues and seek a resolution. Over the past few months, multiple guests at this property have repeatedly failed to comply with the statutes outlined in Article 5, which short-term rentals are now required to follow, and that's what I was willing to abide by. Unfortunately, the owners have not held the guests accountable, and it's leading to more and more disturbances. And in contrast, I consistently monitored the property at 3075 that was last in question, and tried to go through the proper procedures and get the CUP and maintain proper oversight. But your board denied my conditional use permit, which you have the right to do. But short terms required diligent oversight and strict adherence to regulations. And the owners of 3035 Waterworks have clearly demonstrated an unwillingness to fulfill these responsibilities. It is imperative that the board holds them accountable, just as they have with other property owners who comply with the rules. Allowing one unit to operate in violation of Article 5 while denying another compliant unit the opportunity to continue operation is not fair to the neighborhood. I urge you to deny this appeal and require the owners of 3035 Waterworks Road to obtain the necessary conditional use permit, ensuring they follow the same rules and standards as everyone else. And just to add, I know when I first moved in that it was not a short-term rental in 2020. I think they stopped that because of COVID. It shut Airbnb down pretty much. And they had rented it to the Center kids whenever Center allowed seniors to live off campus. So that was at least a year there where it was not in operation as a short-term. That was just an argument that was brought up by their council. And then that happens a lot. I know I think in the statutes of Article 5, it's like 30 days or less is short-term. And there are constantly groups of people. As one of the pictures I passed around, there was a film crew there that stayed for over a month, playing loud music like every single night there in April. It's just, and there were no repercussions. There were no warnings to them, even after complaints. And then they were allowed to stay for their entire time. I think the Martins are just trying to make money off the neighborhood and off the property and off the location, and don't really care about the heart and soul of the beautiful area that we are lucky enough to call home. So, thank you.
Thank you.
My name is Greg Covey, and with my wife Lori Hartman, we're the owners of 3055 Waterworks. We have the unique situation. I followed Mr. Pike because we actually flank the property. So I have the unique experience of watching the transition of the property. We purchased our lot in the fall of 2016 and began clearing it and building shortly after that in the spring and summer of 2017. My memory, and that aligns with what Ms. Gary said, she was referring to my phone call, which was that I actually spoke with the long-term renter in that property during 2016 and 2017 a number of times. And then sometime between when we completed our construction and moved in the summer of 2018, in August, the property had transitioned from a long-term rental to a short-term rental. So it was right around the time we moved in, somewhere maybe slightly before that. So we're in the unique situation of having rentals on both sides of our property. The Pikes, as Jacob Pike explained, did apply for a conditional use permit for their short-term rental to operate legally at 3075. They were willing to comply with the regulations and requirements, and their application was denied by this board. Now, I understand the council's point is accurate that that conditional use permit process didn't exist at that time. Short-term rentals were just coming on in the county. So the Martins they've been operating this as a short-term rental without oversight or any regulation for about 6 or 7 years now. They are absentee owners. I appreciate Connie Privet is a very hardworking and congenial manager of the property, but she's not the owner, and she cannot control the behavior of the repeated short-term renters that we have at the property. I expect other residents to testify about the many disruptions of traffic congestion, noise, animals, and unregulated use that this property has caused the neighborhood. As the adjacent property owner, we do not support the continued operation of this rental as a short-term rental without regulation, oversight, or taxation. It's not fair to us or to the neighborhood. I want to make a couple other points. I know the Airbnb listing indicates that the house accommodates up to 16 guests. It's a 5-bedroom house, according to the advertisement. I'm not sure if that aligns with the PVA assessment of the property. There was a film crew that stayed over a month this spring. Traffic was a problem. Noise was a big problem. We also had a recent renter that several gentlemen had dogs that they had entered in field trials. There was, I think, 12 dogs on the property. I spent a couple hours cleaning up dog excrement from the yard that my dog was walking into. I did make a call to Mr. Martin and didn't get a return call, but I did get a return call from Ms. Privet about a week later, but I had already cleaned up the mess. Years ago, I just recalled that there was an incident where there was a very large party on the deck during New Year's Eve, and there were gunshots fired off the back of the deck towards the lake. That was a major concern. So again, we don't, as a neighborhood, or specifically my wife and I as property owners, do not agree with the continued, or the ability to continue to operate this property without any regulation or oversight. And we urge you tonight to deny this appeal. Thanks.
Anybody else?
My name's Mark Bruner, live at 2825 Waterworks Road. My testimony is truthful. I can tell you, as of September 2 in 2017, it was a short-term rental. There was a bachelor party, and one of the guests became an intruder in my house, and there was another person behind them when we looked out the window. So after my wife got the kids to one room, I cleared the house and then confronted this gentleman who was from Maryland. And he was high and hallucinating and aggressive and big. And I wasn't going to let him to my family. So he came within just a second or two of losing his life, because I wasn't going to let him come toward my family, which is where he thought he should have been. So I stood for 20 minutes until the sheriff came from Perryville. And while my wife's on the phone begging the dispatch to send somebody from Garrett. So that's the kind of crap we don't really want on our street. And that fear and sense of violation doesn't just go away when someone comes in your home uninvited and breaks glass in your kitchen and is aggressive towards you. That's something that it takes a while to get over, and sometimes you don't. So that's my reason for not wanting this mess down the street. Thank you.
Thank you. Anybody else would like to speak?
This is my district as well. And I was very involved in, this is one of the main reasons we started rewriting the zoning ordinance, was because of short-term rentals. There was nothing on the books at the time, which this was all a new thing for us. And so when I came in 2018, 19, that was one of the first things that we wanted to do. We worked with Steve Hunter to really give the property owners and the citizens the option to not have these commercial places on their property, especially out in the county. In the city chose a different route. They allow it by right, but myself and a couple others fought very hard to make sure that the citizens of the community, of that part of the community, had the opportunity to speak out against it and really choose whether they wanted to have have these businesses on there. There was one on Kings Mill that was problematic, and then this one was one of the others that really caused a lot of issues for us. And so I'm glad to see that the people on Waterworks will possibly get some relief by you all following, the process here. And it's black and white. Mr. McGuire talked about earlier, and then Mr. Brown talked about earlier, 2 wrongs don't make a right. So I encourage you guys to please, side with Michaela, your director, on this one, and not allow it to go forward. Thank you.
Anybody else like to speak? Yes, sir.
My name's Jim Boyd. I've lived on Waterworks Road 45 years, so I know what it's like out there. And you're an attorney, you're paid by the Martins to be here, is that correct? $150, $200 an hour, and you're all dressed up. How many other people are here that don't want this? 1 against 40, and yet this is a public hearing, am I correct?
Yes, sir.
And so this is the public telling you what they think of Michaela's judgment. They think she's right, and we ask you to vote to deny the request and realize that the Martins have been operating for years without a permit and need to be stopped. Thank you.
Thank you. Anybody else like a chance to speak against the appeal? Not seeing any. Is there anyone here that would like to speak in support of the Martins' appeal? Seeing none, we will close the public input portion of this hearing. I will turn the floor back over to Henry, and then maybe you'll get a chance at her final words. Yep.
Thank you, Mr. Chair. The Martins possessed no conditional use permit before the ordinance was amended. Short-term rentals were nowhere else permitted in that previous ordinance, and so this was not a lawful use, and thus it cannot receive grandfathered status. The case law on non-conforming uses that I was looking at today, I found no case where the non-conforming use was not described as having been permitted under the prior regime, and this was not something that was permitted under that prior regime. Want to make a reference to this idea of 2 wrongs and a right. There's case law on that as well, which says that we're not doomed to repeat any mistakes that were previously made in enforcement. If a prior director was more permissive and a current director wants to take a different enforcement route, they're permitted to do that by Kentucky law. That's the Attorney General versus Johnson case and Sebastian Vore. I'm going to remind you that the question before you is, did your director possess the relevant facts, and did she correctly apply the law? Our interpretation that there's no non-conforming use does not, in this case, or others like it, it does not have to be economic capital punishment. The way to fix this would be to apply for a conditional use permit. And if you're concerned about some ripple effect with other similarly situated short-term rental owners, that's a path forward for them if they should want to continue that use. Moreover, the conditional use permit gives you a more efficient means of enforcement. You can more easily call these operators to task for violations. You can place conditions on the uses, and you can revoke the permit if they don't follow those conditions. And so in light of that, I would ask you to adopt the findings that I've submitted to you and deny this appeal.
Ms. Baxter?
The reality is, back prior to 2020, the ordinance was silent on rentals. It didn't say anything about, rules about renting anybody's property out on a short-term or long-term basis. Rentals are permissible. People can rent their properties. I'm sure there's plenty of folks renting properties in Boyle County and in Danville today. The reality is, they weren't regulated. The city found a need, or this planning commission found a need to do so and started doing that in 2020. The Martins didn't come in under the wire here. They operated this short-term rental consistent with the ordinance and the permitted use of a single-family detached dwelling prior to 2020. This idea that, they should just apply for a conditional use permit. Properties that have a valid non-conforming use are not required to seek and obtain a conditional use permit. That's not the tact that Lexington has taken. I don't think that's the tact that any other of the communities in Kentucky or elsewhere, for that matter, have taken as far as these short-term rental regulations that are, obviously a big sort of more recent issue. Henry and I went to law school together. When we were in land use planning class, the sort of classic non-conforming uses that you learn about, might be a strip club or a liquor store or some use that the community, for whatever reason or portions thereof, don't want in that community, and that prompts the community to enact an ordinance putting rules and regulations on those things. The case law makes clear that those uses, as undesirable as they might be, are valid nonconforming uses. Those are protected property rights under Kentucky law and under court decisions and statutes. I am hearing a lot of frustration, and if I'd experienced some of the things y'all experienced, I'd be frustrated too. I'm gonna make sure the Martins hear about it, but the reality is I don't know that they've heard about a lot of these issues, and that's a problem. The fact that there's been issues with this property is relevant to this body's determination tonight in that it explains how we got here, how it landed on Michaela's desk and how she came to make this decision. But the reality is her decision didn't have anything to do with any of the things that folks are complaining about here. It was a determination based on the law and the plain language of the ordinance. It was a determination, in her determination, she found that looking at these uses that were permitted and these conditional uses, that this short-term rental was the kind of thing that should have had a conditional use permit and failed to do so. I submit to you that that is inconsistent with the zoning ordinance that I sort of walked through today. That's what we're here about. That's what my clients were notified was the basis for this determination. As far as some of these other things, there are different avenues to deal with that, but finding that my clients do not have a valid nonconforming use is not the right process by which to deal with these issues that folks are complaining about tonight. So let me look through my notes really quickly. Oh, I heard something about taxation, not paying taxes. My clients have always paid all the taxes that they're supposed to pay as to this property and as to other properties also. So that is not correct, respectfully. And I guess Mr. Pike and his short-term rental, again, that's fundamentally different from the situation at hand. That was not a pre-existing non-conforming use. This is, and I'd ask you to appeal to your common sense and look at the ordinance and reverse the planning staff's decision in this case. Thank you.
Any questions? No. So it's up to us now to either make a motion to agree with their appeal or deny their appeal. I did that. Thank you, sir. No problem. So would entertain a motion to either side with the Martins and approve their appeal or to deny their appeal if there's no further discussion.
Are we in discussion now?
Yes, sir, we are. What's that? All right. If you would turn on your mic there so we got that loud and clear.
Yes, I'll make a motion. I'll make a motion to deny the appeal.
Mr. McGuire, does your motion incorporate the findings that I submitted?
Yes, for the findings that Michaela came up with, and that I deny the appeal.
Got a motion? We have a second from Jim. Any further discussion?
Which is the yes and which is the no?
So a yes vote is siding with Michaela and Planning and Zoning because his motion is to deny their appeal. So just to make that clear, if you're voting yes right now, you are agreeing with Lonnie's assessment that we deny the appeal. A no vote would be the opposite of that. So,
Quick question.
yes, sir.
So the Martins never had a non-conforming use permit, is that correct?
That is correct.
There was never any permit obtained?
Correct.
Okay. And there is no grandfathered status by your findings?
That's the argument I'm making. You've heard that opposing counsel views it differently, but I would argue that since it wasn't listed in the ordinance, and since they didn't have a conditional use permit, that it wasn't lawful, and thus that it cannot be grandfathered.
Thank you.
Well, and is it correct that, excuse me, they do have an option of subsequent to this hearing, applying for a conditional use permit?
Yes, sir.
So we have a motion by Lonnie and a second by Jim to deny their appeal. All in favor?
Yes.
All, well, everybody decided, so there are no nays, so your appeal is denied. Thank you. Next on our agenda is a variance at 474 West Lexington Avenue, which is a single-family residence that I reside in. So I'm going to turn this meeting over to Lonnie at this time and step down at this moment.
At this time, Tyler Montgomery has applied for a variance to reduce the side yard setback from 10 feet to 4.60 feet to allow for a covered porch on the rear of the existing home of 474 West Lexington Avenue. The property is a single-family resident, R1-A. At this time, I'm going to leave a lot of this over to Michaela.
Yep. I'll just run through some things really briefly and then you can speak. Yep, so the property's located at 474 West Lexington Avenue. I want to apologize. I misinterpreted the drawing that was submitted by the applicant here. I thought that, I originally wrote on the agenda that I thought it was this front porch here, but they're actually proposing to build an addition on the rear here over this concrete patio. The property is zoned R1A, single-family residential. Typically, let me look at the exact here. Typically, in the R1A zoning district, we would require a 70-foot lot width for that zoning district. These are older lots that you find, in more of the historic areas of downtown. So this only has a lot width of 41 feet. So it's a very narrow lot for this zoning district. So when you're looking at a side yard setback, you do have to consider the lot width and whether it aligns with the zoning district and if the zoning district's requirements on it are strict due to it being, 29 feet less than what you would typically find in the zoning district. So that's really all I had. Are there any questions for me on that? Okay.
So my name's Tyler Montgomery, and all the findings that we've looked at, this side yard for a typical historic home here in Danville is 10 foot, which is quite large considering that the home itself actually sits in that 10-foot side yard. We are proposing to simply stay within that existing footprint where the home is. It's not to exceed outside of that. And that is mostly just to stay with the character and architecture of the home. We wanted to keep the craftsman style with this addition and make sure that everything that we do to this home moving forward takes a correct eye at looking at the design styles of this. So to get the covered porch that we wanted to, we're trying to incorporate a existing concrete patio that we could see on that previous slide. That concrete patio extends to the existing side yard that you're seeing there, which is why we are stepping into that 10-foot setback. Basically, just to kind of encapsulate that space that's already there and not create any dead space. We want to be able to push onto that 10-foot side yard and be able to accommodate with the architecture of the house. And to do that, we need to step into that side yard.
Open the floor here.
Forgive me, I'm new at this. I'm learning tonight.
Yeah.
So what were you saying?
Yeah.
Oh, yes. This time you open the floor for anyone against this. Any more speak on in favor? Thank y'all for making my night easy.
Do I understand, you're going to come even with the existing building?
Correct, yes.
And there's no concern by the neighbors on that side? What about fire safety?
Because it is a screened porch, the fire code for that space that we are attaching the screen porch to, there are still 2 ways of egress. So we're not blocking any ways of egress out to the space. And currently, the side yard of the adjacent lot, I believe, is close to 15 or 20 feet to the nearest structure. So there's still a large green space.
Any decision made by the Board of Adjustment would not override any fire safety codes, building codes, et cetera. They would still be required to get appropriate building permits and all that, so.
Okay.
Mr. Henry, you have anything that you want?
I would submit to the board that if you want to make a motion to approve, if that was your inclination, that you could find that there were unique circumstances on the lot, that it's a lot of record and very narrow, and for that reason, it's also not an unreasonable circumvention of the zoning ordinance.
Anybody?
I certainly agree with that, and I would move approval.
We got one. Second. It's been second and approved that we move forward with this.
You want to vote?
Are we
Everyone
voting?
vote? All in favor? All ayes, no nays.
Motion passes.
Motion carried.
Thank you all.
Thank you.
There are no other public hearings on the agenda tonight. And I don't see any old business, but is there anything else that is not presented to us for old business?
Nope,
Any new business?
nope.
Like to entertain a motion to adjourn. Motion by Willie, second by Lonnie. All in favor?
Amen.
Aye. Thank you all.
Go for it.
Yes, sir.